Very good morning, friends. Welcome to episode 3, IPC Indian Penal Code 1860. And there are around 8 episodes. Myself, yours, Manoj from Maxacon LLP. And I would request all of you to kindly subscribe Maxacon YouTube channel so that you will be, and also press bell icon so you will be intimated of posting of any future videos. It is just a 10 to 15 minutes small YouTube video that will give you the best for your examinations. Now, in the earlier episodes, we studied criminal offense, civil offense, crime, fundamental elements of crime, stages of crime, and Indian Penal Code, its features, jurisdiction, intra-territorial jurisdiction and extraterritorial jurisdiction, kinds of punishment, burden of proof, criminal conspiracy under Section 120A and its punishment under Section 120B, criminal misappropriation of property under Section 403 and 404. Now let us look into the criminal breach of trust. And what is this criminal breach of trust? See, Section 405 of Indian Penal Code 1860 defines criminal breach of trust and its punishment is given under Section 406. Let us now look what is criminal breach of trust. Whoever being entrusted with a property or with any dominion means control over the property, and he does 4 things, that is dishonestly misappropriates or converts that property to his own use, or dishonestly uses the property, or disposes of that property in the market for benefit. Now, in violation of any of the direction of law or of any contract, whether it is express or implied, and he willfully suffers the other person, then he commits criminal breach of trust, right? So criminal breach of trust, if you look into it, there are 3 elements. One, entrustment of property or its control to someone. Now that someone, he second element is that he dishonestly misappropriates or otherwise converts to his own use that property, or dishonestly uses or disposes of that property, right? And all these actions he is doing in violation of law or of any contract. Contract may be express or implied. That constitute criminal breach of trust. Now, punishment under criminal breach of trust is imprisonment, which may extend up to 3 years, or with fine, or with both. Now, let us look into an illustration. This illustration is given in the Indian Penal Code itself. Now, mostly the companies, all the companies who are collecting the employee contribution relating to the provident fund or ESI, that has to be deposited with the government. Now, what this particular employer, that the company, what it does is that they collected the employee contribution and they have to add the employer contribution and deposit to the government. But rather, this employer, he dishonestly used for his own purpose. That constitute criminal breach of trust. Another one example, if you look on the right hand side, you will see there are a couple of illustrations given in the book. Here, an employer, they deduct, no, that here, A is an executor of a will of a deceased person. Deceased person gives that power to A. Now, will directs that the property has to be divided among its legal heirs. But A, without their knowledge, appropriates it for his own use. That constitute violation of a contract and criminal breach of trust. Now, assume assume that A is residing in Calcutta and Z is residing in Delhi. Both of them entered into a contract. That contract is that Z will give the money and A have to invest that money in company X. Z remits rupees 1 lakh and A now takes that money and uses for his own purpose. Here it is a violation of contract. This is a criminal breach of trust. Now assume that A, in good faith, he realizes that depositing money or investing money in company X is a waste, and he invested in the Bank of Bengal, and that now assume that there is a loss in the Bank of Bengal. This time, now this is not a criminal breach of trust, but Z can initiate a civil action because he violated the contract. Now, another one example is that A is a revenue officer. He collects public money as per the law, and he has to deposit that money with the government, but he converts to his own use or misappropriates that money. That's a criminal breach of trust. Next, this is the case law with respect to criminal breach of trust under section 405. Here, we are Dalal versus Yugendra Narangji Thakur, and this is in the year 2008. Supreme Court held that entrustment, if it is missing, the word entrustment is the main ingredient in the criminal breach of trust. So, entrustment of property or its control of the property, that if it is missing, that would not constitute a criminal breach of trust. So if you look into it, breach of trust is a civil wrong, and that along with the guilt intention, that is mens rea, that will constitute criminal breach of trust. So the expression direction of law, if you look into it, it's not just simple and pure law of legislation. It also includes directions given by the government authority and instruments and circulars issued by the authority also. So what the Supreme Court has said in the case VR Dalal versus Yugendra Naranji Thakur in 2008, it is Supreme Court held that the main ingredient of a criminal breach of trust is entrustment or handing over the control. Now, or dominion. If it is missing, that would not constitute criminal breach of trust. Now, normally breach of trust is a civil wrong. It is added with the guilt intention, that is mens rea, then it will constitute as criminal breach of trust. Now, the direction of law, when it says it is just the not just the law or act, it includes directions, instruments, circulars issued by authority. Now, another one case is very interesting. That is Pratibha Rani versus Suraj Kumar in the year 1985. Here, Supreme Court held that. First of all, let us understand the fact of the case. Here, Pratibha Rani was separated from a separated wife of Suraj Kumar. Now, he complained that her husband and his family, they demanded dowry, and she gave ornaments and other property worth of rupees 60,000 to husband and his family. Later on, she experienced there is no food, harassment and beating, and they were trying to extract more money from her parents. Now, Supreme Court held that Sridhan property was entrusted to her in-laws dishonestly misappropriated for their own use. That is, their here in-laws and husband, they misappropriated the property handed over by uh, Pratibha Rani. Now, she made out a clear and specific unambiguous case against the in-laws. So the accused were held guilty of offense, and she was held entitled to prove her case, and no court would be justified in quashing her complaint. It is a criminal breach of trust. Next case law is Omkarnath Mishra versus State. This 2007. This is similar Sridhan case only. Here again, Supreme Court held that there are two distinct parts involved in a criminal breach of trust. One is obligation in relation to property, creation of an obligation in relation to property over dominion or control is acquired by the accused. Second is the misappropriation or dealing of property dishonestly contrary to the terms of the obligation created. Now, the next case is very interesting case, SK Alag versus State of UP. This is here the petitioner SK Alag was a dealer and he was dealing with the Britannia biscuits, and the company Britannia biscuits said all of a sudden because of the various reasons they cancelled the dealership, but SK Alag submitted the money, deposited the money, and he has not received the goods, but the company already returned, but SK Alagh has not accepted it. Now, in this particular case is a very peculiar particular case. SK Alagh has not accepted the money given by the company, and company had record, and but at the same time he filed the case against the company that the company had not given either the biscuits, the goods, or the money back. Now, Supreme Court held that where demand drafts were drawn in company for supply of goods, and neither of the goods were sent by the company nor the money was returned, the managing director of the company cannot be said to have committed the offense under Section 405 of the Indian Penal Code. It was pointed out that in the absence of any provision laid down under the statute, a director of a company or an employer cannot be held vicariously liable for any offense committed by the company itself. Now, this section 407, 408 and 409 is much stricter as compared to section 405 because there is a huge trust is involved in it. Section 407, criminal breach of a trust by a carrier. When you give a property, whomever is entrusted as carrier, wharfinger is similar like a warehouse, and he commits a criminal breach of trust in respect of that property, then it will be more stricter. The punishment here is up to 7 years and fine. Now, section 408 says criminal breach of a trust by a clerk or servant. Now, clerk or servant, they had to act with utmost integrity. But here, a clerk or a servant is entrusted in such capacity with property or with dominion over property, and he commits criminal breach of trust in respect of that property, then up to 7 years and fine, imprisonment up to 7 years and fine. Now, section 407 and section 408, if you look at it, one is you are giving a property or its dominion to a carrier. Property you are giving entrusting to a carrier. Now, section 408, you are giving the property or its dominion to clerk or servant. Now, in both the cases, the punishment, if they commit criminal breach of trust, the punishment is imprisonment up to 7 years and fine. Now, section 409, here, criminal breach of a trust by public servant, banker or agent. Here, punishment is much more stricter. Here, public servant, banker, merchant, factor, broker, attorney or agent, they are entrusted in such capacity with property or with dominion over property, and they commit criminal breach of trust in respect of that property, then imprisonment is up to 10 years and fine. In the cases of 405, imprisonment is up to 3 years or with fine or with both. But in the case of 407 and 408, imprisonment is up to 7 years and fine, not or here. Now, in the case of section 409, here the case is involving public servant or banker or agent. It is much more stricter. So, imprisonment is up to 10 years and fine. Now, there are three case laws. One is Bega Singh versus State of Punjab in 1994. Here, the appellant was a tax clerk in the municipal committee. He collected the arrears of the tax and deposited after 5 months in the committee fund. So there is a timing. He delayed it by 5 months, and then he pleaded. The money was already given to the cashier Madan Lal, who defaulted. But cashier proved that he had not received the money from Bhagat Singh. Here, Bhagat Singh is liable under section 409. Imprisonment may be up to 10 years and fine. Now, Bachu Singh versus State of Haryana 1999. Here, appellant was a Gram Sachiv in municipal committee. So, based on his responsibility and capacity, he collected rupees 648 from 30 villages towards house tax and executed its receipts also, but not remitted the same with the government and converted it to his own use. So Bachu Singh is liable under section 409. Now, Girish Saini versus State of Rajasthan in 2011. He is a public servant, was accused of neither depositing nor making entries of stationery required for official purpose. Now, accused public servant was in charge of a store and in the concerned department at the time of commission of offence. Hence, entrustment was proved. The stationery was entrusted to him. Now, it was held that accused not took the benefit of misplacing one of could not take the benefit of misplacing one of the registers of the company as he could not prove maintenance of two registers by the department. Here, Girish Saini is liable under section 409. With this, the episode 3 comes to an end. I'm wishing you a happy reading and happy listening. Please subscribe the channel and press the bell icon, and your episode 4 will be following soon.